Hello friends, welcome to the series of income tax cases. Today the issue which we are going to take up is a very important issue on section 50C and 54B. In the today's deliberation, the first matter relates to section 50C, where there is a provision that if the date of the agreement to sell and the date of the registry are different, then the assessee can choose to take the stamp duty valuation as on the date of the agreement, provided that the consideration has been received at the time of the agreement through banking channels. And the second issue is that for claiming section 54B exemption, whether the assessee can purchase the new land in the name of the son. These both the issues have been taken up by the Indore Tribunal in the case of Siddhulal Patidar versus Income Tax Officer, and this case has been reported in 111 ITR Tribunal at page number 541, and the date of the judgment is 28th February 2024. Friends, in the present case, the date of the agreement and the date of registry were different, and the assessee was pressing that the stamp duty valuation on the date of agreement to sell to be taken. But when the assessing officer denied and the matter travelled to the tribunal, then after examining the facts, the tribunal came to know that in the present case, the cheque has been received by the assessee after the date of agreement to sell, and that cheque was also post-dated. And the facts of the case was also suggesting that the assessee has received the cash before agreement to sell. The tribunal said that in the present case, the true interpretation of section 50C has not been followed by the assessee or has not been understood by the assessee, and the assessee is trying to manipulate that provision by taking the post-dated cheque, and that was also after the agreement to sell. So on the basis of the post-dated check, especially where some cash has been received before the agreement to sell, then in that cases the benefit of that provision, that when the date of agreement to sell and when the date of the registry are different, the assessee has the option to take the stamp duty valuation on the date of registry. Then in the present set of facts and circumstances, the assessee cannot take that benefit. The second issue was that the assessing officer has denied the exemption of section 54B to the assessee because the assessee has purchased the new land in the name of the son, although there were no denying the fact that whatever the investment has been done in the new land by the assessee was from the sale proceeds of the old land, but it was the contention of the revenue that in the case of CIT versus vegetable products, the High Court has given a verdict that decision was given by the Punjab and Haryana High Court that if the land is purchased in the name of the son, section 54B exemption cannot be given, and some other assessee has filed the special leave petition in that case because that case was relating to some other assessee, and in that special leave petition, the SLP was dismissed by the Supreme Court by a single line summary order. So the revenue was saying that even the SLP has been dismissed by the Supreme Court, so now it has become the law of land that the section 54B exemption cannot be allowed to the assessee if the land is purchased in the name of the son. But contrary to that, the assessee was saying that there are some decisions of various high courts which allow this exemption, and even the jurisdictional high court was giving the decision in favor of the assessee in some other cases. Now the point of discussion was that whether the dismissal of the special leave petition by the Supreme Court by a single line summary order can be treated as a pronouncement of final law by the Supreme Court. When the tribunal heard the matter, the tribunal said that in the present case, the Supreme Court has dismiss the special leave petition by a single line summary order, which has the only effect of dismissal by the Supreme Court in that decision of High Court, and by giving the summary decision by a one line order, the Supreme Court has the intention of only keeping that decision intact, and the Supreme Court did not want to get disturbed that judgment in that particular case, and in any case it is not become the law of the land by a single line summary order. So the tribunal said that in the present case, since the assessee was having the favorable decision from his jurisdictional high court and various high courts, so that decisions will prevail, and the Supreme Court decision by a single line order will not come in the way of the assessee for denying him the exemption under section 54B if the assessee purchases the land in the name of the son. Friends, this case is very important as far as the interpretation of the law in regard to dismissal of the special leave petition by the Supreme Court by a single line summary order. At the end of this video, once again I am repeating the name of the case. The name of the case is Siddhulal Patidar versus Income Tax Officer, and this case has been reported in 111 ITR Tribunal at page number 541. The matter has been decided by Honorable Tribunal Indore, and the date of the judgment is 28th February 2024. Thank you, friends.